Hi, I am Andrew Meinzer of Meinzer Law Firm PC. In this video, we'll start to focus on the different types of California special needs trusts. This is the second video in a three-part video series. In the first video, we discussed who needs a special needs trust and how a special needs trust can help. Generally, there are two ways to create and transfer assets into a special needs trust. One way is the person who anticipates receiving government benefits transfers his assets into the special needs trust. This is called a first person or first party special needs trust. The other way is that someone else transfers her assets into the special needs trust for the benefit of the person who anticipates receiving government benefits. This is called a third person or third party special needs trust. For both types of special needs trust, the person receiving or anticipating receiving government benefits cannot be the trustee in charge of carrying out the terms of the special needs trust. Also, all special needs trusts must be irrevocable. A trust that is irrevocable generally is not changeable. If you receive or anticipate receiving government benefits, then you need to be careful about creating and transferring assets into a special needs trust. Some government benefits have look-back and disqualification rules. Those rules could disqualify you from receiving government benefits if you give away your assets. Transferring assets to an irrevocable trust, such as a special needs trust, often is considered giving those assets away. Accordingly, transferring your assets to a special needs trust may be the same as giving your assets away and cause you to be ineligible to receive government benefits that are based on financial need. Additional restrictions apply to first-person special needs trusts. For example, a first-person special needs trust needs to contain language requiring that after your death, the trustee must reimburse the government for any reimbursable government benefits that you received. The intended beneficiaries of a first-person special needs trust after your death will not necessarily receive any inheritance from the trust after your death. They would not receive anything until the trustee has completely reimbursed the government for any reimbursable government benefits that you received during your life. Again, a third-person special needs trust contains assets of someone other than the person who receives government benefits. And there are two types of third-person special needs trusts. By the way, neither type of third-person special needs trust needs to contain the government reimbursement language required in first-person special needs trusts. The two types of third-person special needs trusts are 1. A standalone third-person special needs trust, and 2. A nested third-person special needs trust. And we created these names for these types of third-person special needs trusts. They're not official. Other people may call them something else. We'll continue discussing these third-person special needs trusts in the third and final video in this series. The advice and guidance of an attorney experienced with special needs trusts is invaluable for attaining your goals in these types of cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients achieve their goals regarding special needs trusts. Again, I'm Andrew Meinzer of Meinzer Law Firm PC. If you know that you need our help, or even if you just have a question, please contact us and let us take care of you.